Good afternoon. Our next panel will discuss specific ideas to improve California's current system. Our panelists are practitioners in California and have extensive experience working in the criminal legal system with the population we've been discussing today. Our panelists are Judge James Bianco from Los Angeles Superior Court, Stephanie Regular, Chair of California's Public Defender Association Mental Health and Civil Commitment Committee, Matthew Greco, Deputy District Attorney from San Diego County, and Kim Peterson, Senior Attorney from Disability Rights California. Judge Bianco, we'll start with you.
Oh, thank you. Thanks for the opportunity to address the committee. Just to give you a little bit of background, I've been a judge since 2008. Since 2013, I've been full-time in a mental health court. And most of what I do in that assignment is criminal competency. So I think in the last 9 years, I've handled something in the tens of thousands of competency cases. And so I'm going to keep my remarks really brief. Obviously there's a lot to be said about what to do to improve the current state of things. I think the staff memo goes over a lot of that ground and I think covers it. I think that the future is absolutely in community treatment, and in Los Angeles, we've been, I think, doing a really commendable job of getting people into community treatment, particularly on serious felony cases, but we're not nearly where we need to be in terms of scale. The one thing that I would sort of point out that I think was not really addressed in the memo, unless I missed it, was there's a scheme in the penal code that I think is really not working. It's difficult to explain. I've tried for years, including to Judge Espinoza to explain it.
He doesn't understand, nobody will.
This is really getting into the weeds, but there's this whole notion of a community program director that's woven into the penal code, and particularly with regards to competency restoration. And so I'll try to just, without getting too into the weeds, kind of just give you a little bit of an overview and really urge you to consider changing this scheme. So basically, every county has to have what's called a community program director, and that community program director is tasked with lots of different, very important roles under the penal code. So for instance, when someone on a felony case is found incompetent to stand trial, the next thing that happens under the penal code is the community program director is supposed to make a recommendation regarding placement. If it's outpatient treatment, the community program director is supposed to provide that treatment. If there's a suggestion that perhaps something other than a community placement or a state hospital is warranted, that third alternative has to be approved by the community program director. So it's a really important role, and it absolutely doesn't work. In Los Angeles, the community program director is a nonprofit called Gateways Conrep. We do what we're supposed to do under the code. We ask them for a placement evaluation. In 99.9% of the cases, they come back with a recommendation for locked state hospital treatment, even though everyone knows that some segment of this population are absolutely appropriate for community treatment. And so we waste 3 weeks getting their evaluation. They waste lots of resources providing these evaluations. And then, I don't know, some percentage of our folks are then recommended for community treatment by our own sort of county agency, which is the agency that Judge Espinoza used to head up, the Office of Diversion and Reentry. They do a brilliant job of providing community treatment. This is all completely apart from what the community program director is supposed to do and what they actually do. And, from talking to many of my colleagues around the state, it's the same state of affairs in most, if not quite all counties, but close to it. And the one county where I think there's a notable exception is in a small county, San Joaquin, where the community program director is actually their behavioral health agency, or it's someone that's very high up in their behavioral health department. Their behavioral health department has for many years done a really amazing job of providing community treatment. And so because of that, the community program director scheme works really well in San Joaquin County. And so I would urge the commission to study that issue. I'm happy to provide more information if it would be helpful, but it's a scheme which absolutely doesn't work. And so, with that, I'll pass the gavel, so to speak, to my other panelists.
Thank you very much. I'm sure we'll have questions for you when we move to that portion of the hearing. Ms. Regular, is that how you pronounce your name?
Yes, thank you. So I've been a public defender for 21 years and focusing on competency to stand trial for the past 10 years. And, like the other panel said, the goal, of course, should be front-end treatment, really revamping our behavioral health systems. But knowing that we will continue to have a criminal legal system and people with mental illness will continue to be arrested and found incompetent to stand trial, I'm focusing my comments on just reforming the competency provisions. So the first thing that I wanted to touch upon were the timelines. And I really appreciated the comments of the legal director for the committee, as well as the staff counsel regarding the timelines and laying that out for the committee, because the issues with regards to the delays is not just after commitment and for people waiting to get into the state hospitals. And I know that's been the focus of the state for quite a while, but really the delays begin at the moment the court declares a doubt. So, the memo laid out the fact that there are no statutory timeframes. And I just wanted to give the committee kind of a sense of what those timeframes are. So for counties that have like a mental health court, after a doubt is declared, often the case will, sorry.
County?
I'm in Contra Costa County.
Okay, great.
The case will go to a mental health court for appointment of doctors. That often takes a week. The court appoints doctors, and historically, and this is not just my county, but around the state, we would typically get doctors' reports back in about 4 weeks. Because there's such a shortage of court-appointed doctors these days, that's now more like 2 months before we get the doctors' reports back. If everything goes smoothly and all parties submit on those reports, we can move fairly quickly, and the case then gets referred to what Judge Bianca was talking about, CONREP, and that's another month delay. If the case gets set for trial, then we're looking at months, if not sometimes years, before that case gets to trial because there's no statutory priority. The longest that I've ever waited for one of my cases to get to trial on competency was 4 years. And after that client was found incompetent to stand trial, he was never restored to competency. So it's 1 month to get the CONREP report. And I echo Judge Bianca's comments that it is invariably always inpatient treatment. CPDA actually held a roundtable event for public defenders around the state, and we had representation from 20 different counties, including San Joaquin. And when we asked how many counties had gotten an outpatient recommendation in the last 5 years, nobody raised their hand, including San Joaquin. So that's about 3 to 4 months before we even get to commitment. And then once the individual is committed to the state hospitals, we are now seeing delays of anywhere from 6 to 8 months before they get to the state hospitals. So my clients are waiting on average a year before they receive any treatment. So the first ask is to reform the statute to actually provide some timelines so that these individuals are not waiting 3 to 4 months even before they're committed for treatment. And I'm sure you're going to hear from the other panelists about this. You did from the previous panel that we really need to off-ramp these individuals earlier in the process. And so one of the ways to do that is for individuals who have either developmental disability or neurocognitive disorders, traumatic brain injuries, the individuals who are unlikely to ever be restored to competency. Currently, the only mechanism really for courts to off-ramp these individuals is only after they go to the state hospitals and after there's a finding of that they're unlikely to be restored. So that's a year process before we get to what we could have gotten to at the beginning of the process. And that's a very simple fix of allowing court alienists to make a recommendation that the person is unlikely to be restored, and for the court to make that finding, and for that individual to then either be released into a more appropriate setting or referred for conservatorship. And that can occur at the outset rather after years of treatment. The other potential off-ramp is to expand SB 317. So the state really took a bold step to eliminate restoration services for individuals charged with misdemeanors, and that can certainly be expanded to low-level felonies, where just like their counterparts, the misdemeanors, when they return from the state hospitals, they are either released with nothing, their cases are dismissed, or they plead, and as we've heard from so many other panelists, they return within months, years, sometimes days later. Thank you very much.
Thank you very much. Again, of course, we'll come back for questions. Mr. Greco.
Good afternoon. My name is Matthew Greco. I'm a prosecutor in San Diego County. I've been a prosecutor for 25 years. I have been dealing with mental competency, NGI restoration, MDO restoration, as a supervisor of our mental health courts for a number of years. And I am currently, I entered into this particular arena practically through a case that involved an individual who has committed a crime and was found incompetent over a long period of time for a murder. And my focus today, at least my initial comments, I want to recognize that there is a real crisis in terms of mental health. And I think it has been characterized to some degree as not something new. I think it's very akin to the fact that we've become more aware as prosecutors, as defense attorneys, as legislators, as judges. It isn't something new. It is something that has always been there, very similar to domestic violence in the 90s. It has our attention. But there really are two different types of mental illness in the criminal justice system. One of them, I don't want to say it's been dismissed, but it hasn't been the focus. And it is that 10% that Dr. Warburton discussed, and that many other panelists have discussed very quickly when they say violent or dangerous. There is a portion of individuals who have severe mental illnesses, who are potentially competent, who commit very violent offenses. And it is those individuals that we shouldn't forget in terms of the need of, there are some reforms within the criminal justice, the penal code, as well as the welfare and institutions code, to ensure that public safety is protected. And there are people who will be found incompetent and who will come back. And the public safety conservatorship, also known as the Murphy conservatorship, which is found in the welfare and institutions code, is a primary vehicle. One of your other panelists talked about an LPS conservatorship that her son was on. That really isn't a public safety conservatorship, although it is possible in those conservatorships to lock someone up as well. But there are flaws in the system that I am continually attempting to address, where individuals, we're trying to find a way to protect those individuals, or protect the public from individuals who have committed murders, rapes, other very serious crimes. And they come back, and because of some idiosyncratic law that we have, or some just the way the code is written, we can't get those people into those conservatorships. I would also point out that there is a sense of urgency, and it has been discussed before about off-ramping people. And oftentimes you hear people, and I've heard it when I participated in the IST working group, the statewide working group, where we talk about 1170H offenses as somehow being nonviolent. And that would be a good group of people to do something different with. And I would also note that there was SB, what was it, 237 that just reformed or redefined the misdemeanors. That, for instance, the types of crimes that are that are included in those would be somebody like that did a lewd in public type of charge. That person would not be restored, and that is a very common type of misdemeanor. Finally, I would also I would mention that the 1170H would include individuals that drive drunk, elder abuse. There's a whole series that people might have some issue with in terms of simply offloading them onto some other type of diversion. And then finally, as a checkup, there has been some discussion about the elimination of restoration for misdemeanors. And I would say that in this county, those misdemeanors are not receiving, there's no diversion treatment. There's those types of treatment for misdemeanors. Somebody who has committed a lewd act, but is not competent, they're not receiving treatment. So the goal of the legislation really is being thwarted because it doesn't exist, at least in our community. So thank you.
Thank you. And Ms. Peterson.
Good afternoon. Thank you for having me. My name is Kim Peterson, and I am an attorney at Disability Rights California. Unlike the other attorneys on this panel, I am not a practitioner in the criminal legal system. I have represented clients for the last 17 years who have mental health disabilities in civil proceedings, including civil commitment and other types of cases. So my perspective here is really about the involvement of the community-based system in treating the population that we're talking about here today, which is the population of people who have been found incompetent to stand trial. I'd like to echo something that the panelists on the previous panel said, which is to solve the competency crisis, California needs to solve its mental health crisis. We need to fix the system so it is set up to avoid the need for court-ordered treatment altogether, whether that's through the criminal legal system or through civil commitment, such as conservatorships, assisted outpatient treatment, and the new proposal for care courts. This is a complex task. I completely understand that, and I understand that this goes beyond the scope of the penal code. But this is a complex problem and requires solutions that involve many different systems. And so I will try to keep the rest of my comments focused on things that I think are more within the realm of the criminal legal system. One of the things that could be done is to expand diversion opportunities, which I know this committee has looked at in the past. But I just want to go into a little bit of detail about what that looks like. Diversion should be offered at the earliest possible opportunity in the criminal legal proceeding. And I think that you all may be aware that the Department of State Hospitals has allocated a significant amount of funding in past budgets and this year's budget to subsidize diversion and community-based restoration for people who have already been found incompetent to stand trial. But as my colleague Ms. Regular has pointed out, a finding of IST may come after several months or years of unnecessary incarceration. So one concrete thing that the legislature could do, either through the budget or amendment of the Welfare and Institutions Code or the Penal Code, is subsidize diversion for a broader group of people than those people who have already been found incompetent to stand trial. This will allow diversion of people from the criminal legal system at an earlier point in time before they have to endure periods of costly incarceration, which is not only a big expense for the system, but also traumatic for the people who are having to endure those jail stays. And beyond that, I just had another point to address something that was said in one of the previous panels, which was talking about the need to address the needs of people who are unhoused at the time that they are arrested on charges before they are found incompetent to stand trial. Needing housing does not equate inpatient mental health services. And so outpatient restoration and diversion programs will only be successful if people's housing needs are taken into account in conjunction with their treatment needs. And so for the success of diversion programs really should come hand in hand with housing. And this requires a tremendous amount of resources to be allocated to counties and local jurisdictions, not only for the treatment services to be provided, but also housing. Because in my experience of almost 20 years of representing people living with severe mental health disabilities, it is impossible to achieve stability without stable housing. So with that, I will wrap up my comments and am happy to answer questions if the panel has any.
Sure we will. Thank you all very much as we dig deeper into this issue and this problem. I have a number of questions. I'm going to start with one question that I love all the Judge Bianco and Ms. Regular and Mr. Greg address, which is I really want to try to understand this population that 75% of people who get, if I'm correct, please staff correct me if I'm wrong, 75% of people who are found incompetent to stand trial and are returned to court within about 100 days end up being released based on time served or dismissed charges. First of all, is that your experience? And why is that? Is that because 100 days is about the amount of sentence that they would have gotten otherwise, or that the prosecution has just decided to withdraw charges, or is my data completely off? What's going on? Is it because there's relatively minor charges? Does that answer the question?
There are,
Okay.
sorry.
Go ahead. Go ahead, Ms. Regular. Go ahead.
There are a number of reasons. So one is that because the process takes so long and that individuals aren't making it to the hospital for, a year, by the time they come back, they've pretty much exceeded their sentence. And so either the case is just dismissed or they plead for credit for time served. The second reason is for the individuals who are come back, even though the hospital is saying that they have been restored, the court is not always accepting that certificate of restoration. And they are considered still incompetent to stand trial. And we all know they're never going to get back to the hospital before their commitment ends. And so those cases are dismissed.
Wait, say that again. Say that group.
Yeah, the second group are the individuals who are returned as quote unquote restored, but where the court rejects the certificate, says either the defense presents additional evidence saying this person is still incompetent to stand trial. And we all know because of the length of time it gets to the hospital that they will never get back before their commitment expires. And so typically everybody cuts their losses and the case is dismissed.
Mr. Greco, is that your experience? Oh, I'm sorry, Joe, cut you off. Is that your experience that most of these cases end up being dismissed because of the credit for time served?
No, it is not. And I obviously practice in a different jurisdiction, but that is almost never the case, that a felony is just dismissed upon the return. Typically, I think
or they're sentenced but given credit for time served.
I think the statistic from Ms. Warburton, from my understanding from participating with her on other panels and looking at her statistics, it doesn't break out which cases are dismissed and which cases are pled to, but with credit for time served. I do think there is an element within that statistic the reason that those people aren't going to prison, or a small percentage, is because there is a large percentage where it is somebody who has repeatedly stolen a vehicle, which their sentence would typically be a year in local custody. So, or something along those, even 2 years in with a split, they would have served their time. It is very unusual to, at least in this county, that we would simply dismiss the case. And I think Ms. Regular pointed out one of the flaws that could be changed is the determination of competency. That ability to evaluate is statutory in nature. And there are only now 4 times that can actually be done. And a return from the state hospital is one of the times when there's been a finding of competency. The defense and the defense alone has the authority to request an evaluation. If an individual comes back as being non-restorable, the people do not have the same ability to ask the court to reevaluate. And there's no ability to consider that mental competency is really fluid. And we can't talk about mental competency. It is always at a point in time, and people are found to be competent at one moment and could decompensate and be at another moment. And
I just want to understand this in particular. I mean, there's so many different, as we've been discussing,
understood,
so many different moving parts. I'm just trying to get my around this piece. So there seems to be a large percentage of people, whether it's 75%, of course, it will vary in different counties, of people who are returning to be restored from competency, who have credit for time served. Forget it, let's put the dismissals aside. Is that your experience, Mr. Greco, just to make sure that?
Yes, I don't know that it would be 75%, but there is a very high percentage of people that will plead or if they're returned, yes.
Right, okay. And those would be probably among the less serious crimes. We're not talking about the rape, murders, and child molestations you were talking about. Presumably those people would get long. They would not plead to a year of credit with time served. They would get a longer sentence.
Typically, no, but it could happen under certain circumstances, and I won't go into when that would be.
There are outliers in every circumstance. I'm just
Yes.
trying to the majority. Judge Bianco, is this your experience as well?
I'm unfortunately not the right person to ask because we have a centralized mental health court. So once we find someone has been restored to competency, we send the case back to the criminal court. And so I don't have a good sense of what happens, but this sounds like it's probably what happens in Los Angeles as well, to the extent that I know.
Right, okay. I'm going to keep on going. Yes, Judge Espinoza.
Judge Bianco, we heard this morning from the director of the Department of State Hospitals, and she referred to the FIST community-based restoration program in Los Angeles County as the gold standard. Can you explain to the committee how that works in your courtroom? What is the process?
Yes, please.
Okay, so I'll try not to get too deep into the weeds, but basically, once we get this placement evaluation, which says the person should go to a locked state hospital, we commit them to a state hospital. There's no discussion about community treatment. We have a county agency, Judge Espinoza's old agency, the Office of Diversion and Reentry, which then basically evaluates all the people in the jail that are waiting to go to state hospitals. And they will begin to sort of take over care while that person's in the jail, and in the course of that process, sort of coach the person up, if you will, about the idea of community treatment. And eventually, if they think that person's a good candidate, they'll make a recommendation to the court that person be released to community treatment. And there's a hearing. I'd say the DA objects, some percentage of the time, but much of the time they go along with it because they're familiar with ODR and the work they do and they trust them. But ultimately, one of the judges here will make that call. If they're released, basically they go from the state hospital waiting track to now being treated in a community setting. And what ODR does is they have congregate living houses where there are are anywhere from 20 to 30, sometimes more people living in a house. And the houses are not co-ed. They're either for men or for women. They're run by basically vendors that work very closely with ODR. They provide, the most support that someone could have in an unlocked setting. They are there for competency restoration, but to be honest, restoration is very infrequent. What typically happens is on a felony case, from the time the person is committed to the state hospital, by statute now, it's a 2-year restoration period. Let's say they get dismissed, 4 months down the road, they then would serve or spend the balance of the 2 years at that congregate living house. So it's a very long period of time where they can really engage in services. The treatment team will help them with things like getting SSI if they don't have it, or reinstating it if they had it and lost it. They'll help them with perhaps reuniting with family in appropriate cases if there is family. They'll help them with drug treatment, which is a really pervasive issue among this population. And at the end of the 2 years, that person will be on a path to permanent supportive housing. So ODR also provides a long-term solution for housing in the county. The interesting thing about this is we started ODR back in 2015 on misdemeanor cases when we were looking for an alternative to treatment in the jail. It worked really well. And I think around 2017, the state approached ODR and said, hey, we love what you're doing on these misdemeanor cases. Can you do this on felony cases? And so the county said, sure. And so that program has grown. And at the moment, there's somewhere between, I think it's around 600 people that are in active treatment in the community on felony cases. It's changed a bit. The state has continued to fund restoration treatment, but they've also begun to shift towards mental health diversion for the same population in these same sorts of settings. The only difference is the statutory track that they're on. If they're in community-based restoration, at least theoretically, they could be restored to competency and returned to court to face the criminal charges, even though that really doesn't happen much at all. If they're in mental health diversion, they're on that track for the same time period, same congregate living house, same wraparound services, and so forth.
So I have a question. That makes a lot of sense, and I presume that the standard that the judge applies to whether or not to assign them to the ODR program includes some public safety consideration. Is that correct?
Yes.
All right. Aside from, it seems like it's just facilitated merely because the county originally was paying for it, and the court had always had this authority under state statute. Is that correct?
Yes.
So that how might our committee encourage more of this type of practice? And without just saying more money for programs like ODR throughout the state. I mean, maybe that is the answer, but it seems like the state statutes already provide for the type of programs that are working in LA and are apparently the gold standard.
I mean, it's a great question, and I think it's one which we could talk about for hours and hours. There are a lot of sort of different variables at work here. One is choosing who's going to go into community treatment, and that's going to change based on the culture of a particular county, based on what folks' experiences with this sort of thing. One of the things that I think has been great in LA is I think we've pushed the envelope quite a lot in terms of who gets released. So we see people on some serious violent cases that I think in years past we would not have felt comfortable ordering release, and I'm talking about people who are charged with things like assault with a deadly weapon as a felony. But beyond that, you've got to have a treatment provider like ODR and their vendors that are really, really committed to doing this work. We had trouble when we first tried to do this with misdemeanors. Our own behavioral health department basically sat in these meetings and said, no, we can't do this. We don't have vendors that will do this. And we had enough people in the room that said, oh yeah, no, I think we can make this work. And we were able to get things started and kind of off the ground and show proof of concept that then it grew and grew. Our behavioral health department, our mental health department of mental health is still not involved in this work in any significant way. And I'm not sure that they would be if they were tasked with doing that. So that's another tricky variable. Funding is, I think, a big issue. I think part of the debate that you're seeing around the care plan right now, even when there is funding that's being offered, is the behavioral health departments are still saying, no, we can't do this for reasons which I find kind of perplexing. I know money's always been a big impediment, but now the state's saying, hey, we're going to fund this in a big way. You would think the behavioral health departments would take that up and take the ball and run with it, so to speak. I sort of wonder, and I'm sure I'm going to get in trouble for saying this, but if there needs to be some thinking along the lines of realignment, where you're not just offering the counties the possibility of doing this, but where you're tasking the counties with this responsibility, where they have to do it. And I think there's a lot of really appropriate debate over SB 317 and whether that was a good idea or a bad idea, whether it works in some ways or not. But one thing that I think was a long time coming was SB 317 took jail treatment off the table for competency restoration for people charged with misdemeanors. And I, for one, think that needed to happen, and it never would have happened had it not been through a statutory change. In other words, if you allowed counties and you allowed courts to continue to treat people in jails, they'd do it because it's the easiest path of least resistance to try to provide something that seems, at least in some very small way, like treatment, as opposed to a more appropriate treatment setting like a hospital or a community treatment setting.
So I do want to follow up on that, the 317. How is it going, you think, in Los Angeles County? And you heard the concern from Mr. Greco that, okay, that's fine, we can't offer them treatment in jail, but they're not getting treatment in the community. So this is kind of a failure. And
yeah, so I think I would need to talk a little bit more with Mr. Greco to sort of understand exactly what's happening in San Diego. But I think there are some flaws that are sort of built into 317, such as, since mental health diversion isn't available for people charged with DUIs and registrable sex offenses, with one exception, then there's a class of people, once they're found incompetent, that cannot be put into mental health diversion. So that's just a sort of bug with the way the law was drafted. But beyond that, it really calls upon the counties to provide an alternative to jail treatment. And in Los Angeles, I think we're fortunate. We saw this coming. One of our public defenders, to her credit, said, hey, why aren't we meeting on this? And this was sort of like late September. And so we started meeting on it, and we actually ended up having quite a few meetings with the county CEO. And, basically the county government in LA really got ahead of this. And so on January 1, we kind of knew what treatment we were going to provide. And the SB 317 population was prioritized so that we get full service partnerships. We're sort of at the head of the line for FSPs, if that's what someone needs, for example. But, if a county doesn't want to provide that, I agree. People are just going to be released to the streets, and it's a mess. The other thing about 317 is if someone doesn't consent to diversion, then the options become very limited. And so there is a group which wants nothing to do with treatment, where you can't force them anymore. You have absolutely no ability to other than a conservatorship, which few qualify for, you have no ability to mandate that person into any kind of treatment.
Mr. Greco, I apologize if I missummarized or mischaracterized your earlier statements, but is your principal concern with 317, that there's just no services in the community. Is that fair summary?
That really has been a recurring theme for years as it relates to misdemeanors. And actually, Judge Bianco really identified in his opening the issue with the community program director, that need to make a determination as to placement. That only relates to felonies, at least the way the law was previously written. And so every time we've attempted outpatient treatment in the county for a misdemeanor, we have met with resistance. And frankly, there's not, if the options are you're going to walk out the door anyway, there's really no impetus for for the incompetent individual to seek out treatment. And so that's been a gap. And the other, I very quickly mentioned that when one looks at conservatorships, in all of the committees that I've been on statewide, the public conservator's office I've never seen the public conservator's office ever represented. Their representation always seems to be a county-based official, which is over them, but it's different. So when we're talking about things like offloading or off-ramping somebody and putting them into a conservatorship, I think there is a real misunderstanding about the people that are making that recommendation about what a conservatorship is and what it can do for the community as well as for the individual. And so I would urge, before seeing that type of solution, if you haven't heard from that stakeholder, and not just from a county person who's over them, but in fact, a public conservator who has to do that work, I would highly urge you to do that, because I think there really is a misunderstanding in that regard, and there's a lack of services in that regard. And I would say, in terms of misdemeanors here, they just aren't eligible for that. And I would also suggest one of the reasons the outpatient, even for felonies, when we have individuals who are felony ISTs, or we're doing evaluations and we release them, less than 50% of them show up for their evaluations. So that is of concern as well. And it's one of the reasons that if you were to talk to the doctors that are actually doing them, and we have a set group of 7 doctors that do it, they would say it's almost counterproductive to have someone out of custody before they can do the evaluation, because they don't show up. And that is something we found.
I just want to refocus again on 317 for a second.
Sure.
So it seems like you have two concerns. Again, please tell me if I'm mischaracterizing. First is that there are insufficient programs in the community to provide services, even in the best case scenario.
That's correct.
And the other issue that you mentioned is because they're facing misdemeanors and very little actual jail time, they may just opt to take the jail time anyway and forget about.
No, if they're incompetent, the jail time's not an option. So
what were you saying? So what was the other issue that you were saying about 317 that was the problem? Or was it purely that there weren't the services in the program?
There aren't services, and there's provisions for conservatorships, but those aren't realistic. I mean, I
understand. I understand your issue with the conservatives. I don't want to I'm trying to avoid that issue, because I realize it's not unimportant, but it's a huge can of worms that I'm trying to focus, because there's only so much that I can absorb in one day.
That's very wise.
I'm trying my best. You're good? Yes, no, I know. It's actually, it's we don't have jurisdiction. We don't have standing to talk about things outside the penal code, but that hasn't stopped us before. Judge Espinoza, do you have additional questions? So I just want to say, and again, Mr. Greco, so you've heard that there's proposals to expand 317 to perhaps 1170H cases or non-serious, non-violent cases. And your concern again is that those cases are twofold. Those cases are maybe more serious, small s serious. I'm not using the official.
Sure.
Small s, more serious than might at first blush appear. And number two, that there truly aren't you're just letting people go because you're not really giving them any services anyway.
Well, and from a practitioner's standpoint, there's a much bigger third issue, and that is a person can be IST at any point during the proceedings. Pre-trial is when we typically talk about it, but it can happen afterwards. And it is not unusual to have people reach a plea bargain. So for instance, there's a discussion about a plea where a person is charged with a strike type of offense, something where it's an assault with a deadly weapon or something along those lines. But because the person is 18, 19, 20, at least in our jurisdiction, a defense attorney will float, well, what if we do a non-strike, like a false imprisonment? And we might do that. And once we do that, if then at the time of sentencing, the public that public defender or defense attorney legitimately goes to their client and says, and can't communicate with them. Maybe they have a meth-induced psychosis. Maybe they have something that has happened to them, and they declare a doubt at the time of sentencing, and they are then found incompetent. The result of that is that we didn't enter into what we entered into is not what is actually happening. And what could be a very serious crime that we want to memorialize in some way is now just completely, it could disappear from their record. And what that's going to do is you're going to disincentivize plea bargains. We're going to be sitting there trying to evaluate, is this likely? And this isn't something that happens all the time, but it does happen, and it happens on some of the most serious types of cases, and I've seen it. So there are unintended consequences of just using a broad brush and saying 1170H, and you could have people, if you look through those crimes, those are some crimes that I think some people might say elder abuse should be classified or not classified in that way. So that would be my concern.
Ms. Regular, can you respond? Because am I correct that you suggested 317 should be expanded to include 1170H or non-serious, non-violent?
I did.
Okay.
And if the purpose of this committee is to really look at trying to make things better for these individuals, we are serving nobody by getting a plea from somebody or getting a conviction from somebody with mental illness who is just going to end up back in the system. All we've accomplished is having that person have a longer record, making it more difficult for them to get services in the future. And so, yes, perhaps.
In fairness, what I see our role is twofold. It's to improve the individual's perspective, but also to protect and maximize public safety. And one of the concerns that we've seen so much and heard so much today is that the current system is actually undermining public safety. So the heartland of the recommendations that we make are ways that are conscious and empathetic to defendants and other people in this justice system, but also ways that maximize and improve public safety. So that's why we were, I think, particularly interested in this area, because it seemed that, at least from some of the testimony that we've received, that some of the processes that we're dealing with actually exacerbate people's dangerousness and harm public safety. So
Well,
I guess, go ahead.
Yeah, I mean, one of the issues with why my clients get sicker, why they potentially become more dangerous, is the more time they spend in custody, the sicker they get. And so we are really doing no service to either the individual or the community by keeping them in custody longer, by having them plead. There's nothing that we are gaining by a plea. And by diverting those individuals faster into treatment, the better the outcomes will be. And
I think there's widespread agreement. I don't want to say, Mr. Greco, I don't want to speak for you, but that if we diverting them into genuine treatment, that's the best case scenario. But I guess there's a question about whether or not that is genuine treatment. It seems like in Los Angeles, they have a system where the treatment comes to the court needs to approve it, and that seems to be working well. But if you expanded 317 to this category of crimes, I think Mr. Greco is saying that there's no guarantee that there's going to be treatment. In fact, there's likely not going to be treatment. Is that fair, Mr. Greco? Is that your summary?
I think that's fair. And I think it's also fair to say that mental illness is not the same thing as incompetency, that we have very dangerous people that have mental illness that commit serious crimes. And so there does need to be a distinction between mental illness and competency. And so there's a spectrum, and I mean, just because one is mentally ill and has delusions doesn't mean that they shouldn't be held accountable for certainly violent acts. It also means they need treatment, but that's an important distinction. So I'm talking about competency, not the general treatment of mental illness.
I get that, but so, Ms. Regular, so just to address the question, which is, I agree. I think that there's widespread agreement. If we could divert people who are incompetent to stand trial because of serious mental illness into treatment, that would be the best case scenario. I think there's concern that if we enacted something like 317 to expand it to additional crimes, more serious crimes, that there wouldn't be that treatment available. And that's a concern. How do we address that, or is that a fair concern?
I think it's a fair concern, but the problem that we're seeing in the state is we keep investing in the same thing that's not working. So we're spending millions of dollars on competency restoration that is not working. And so, I mean, I think where we need to readjust.
We just give up. So I get that. And honestly, our budget chair is not here, but the budget is the least of my concerns. I'm much more interested in maximizing public safety. I share the concern that the system is broken, but for these crimes, are you just saying we're just going to give up on the system altogether and say?
No, but we're not increasing public safety by having that individual go through competency restoration. So you heard from Dr. Warburton, they're going to the state hospital, they're coming back in nearly the same condition. They're being exited back to the street in nearly the same condition, and they're coming back. And so if we invest that money in something different and something more effective, then we protect public safety, because the current system is not working.
No, I get that. And she said that they were doing worse off, and I think that makes sense. I guess my question is, okay, so again, focusing on expanding 317 to 1170H or non-serious, or some universe of more than just misdemeanors, some universe of felonies. How do we ensure that they receive treatment and aren't just released on the street? How do we do that? How does 317 do that? I don't even know. Or does 317 not say silent on that?
So SB 317, it gives the courts three options. It's either mental health diversion, refer for AOT, refer for conservatorship, and then the last is dismissal. And with care court, there is the potential that care court will be added as well.
So basically with 317, everyone gets diversion who's eligible for it. And if that's not a possibility for whatever reason, or if they fall off diversion, then you look to AOT or a conservatorship. And dismissal is an option that's available, right from the get-go.
And Mr. Greco, you're saying that people aren't getting diversion even when they're ordered to do it, they're just not participating?
No, I mean, in terms
yes or
of,
no? Not that I'm correct?
You are correct.
All right. So Judge, how do you make people participate in the diversion program?
Well, it's a great question. When people are sort of our first line of treatment for folks that start out in custody is one of these ODR congregate housing situations. And, this is why I sort of smile at the whole debate over care court. I think if you offer, and this is what care court would provide, at least in my understanding, if you provide people who are homeless and mentally ill with the opportunity for housing and treatment, most people will take it and will do great. And that's what we're finding. And that's where 317, I think, is genius, because it forced the county to step up, provide these resources. ODR continued doing the amazing work that they do. And there's a lot of people that are now getting really, good help and a path to stay on a healthy, productive track with housing and so forth. So it's the ones who are really not interested in treatment or are, just so caught up with meth that they really can't engage in a meaningful way, and they don't do well.
If you abscond or run away from your treatment or just don't participate, is that a new crime?
If they run away from treatment,
Yeah.
no, but what we're dealing with now, 5 months into this, or 4.5 months into SB 317, is what do we do when someone keeps running away from treatment, and they're not eligible for a conservatorship? I think AOT for someone that's really truly treatment resistant, someone who wouldn't engage in a really good, robust treatment plan, AOT is not a viable option. That's just a waste of everyone's time. That's my view. Look, if you ask me, I think really the solution for felony restoration is you've got to mandate that there be a meaningful community treatment option. And it's in the code right now, but because of the limitation with the community program director, it just doesn't happen.
Wait, can you just explain that again? So, all right, so, and I realize you spend a fair amount of time.
It's
so
okay.
I do want to dig into this. So you're saying that if the state should require meaningful community treatment programs, which seems to be part of the concerns from Mr. Greco and others, it's already in the statute, but it's not working because the community program director
doesn't have, and here, the
Because
community
my
program
understanding
director doesn't have the resources available. They see their primary role as protecting public safety. Therefore, taking a person who's charged with a felony offense, particularly one that involves violence, which is most of the population that I see, they say, whoa, this person did this and this. We can't treat them safely in the community. I think behind that, besides just a very conservative outlook on who can be successfully treated in a community setting, is a lack of meaningful resources. So the way, ODR has put up, I think there are over 100 of these congregate living houses in Los Angeles. Our community program director, Gateways Conrad, basically has one facility which they use for San Diego and LA, and it hasn't expanded at all in the 9 years I've been doing this work. And I don't think they really would care to expand it. I think it just increases the complexity for them, and that, again, then we're going to send them more dangerous felons that they don't want in the first place.
So let me make sure I understand it. So first of all, resources, obviously, it's, that's number one. And that the Gateway Conrad recommend, is it a recommendation when they say that you do not need to, that a judge does not need to accept? A judge could say,
So basically, I have three options under the code. When I find someone incompetent to stand trial, or a jury does, I can commit to a state hospital facility. I can commit to outpatient treatment, which we're calling community treatment, but it's essentially the exact same thing. There's a third option which exists only in theory, which is the way the code lays it out. It's a public or private treatment facility that is basically has the blessing of the community program director. I've never seen anything that falls in that category, in part because the community program director refuses to approve anything, which I don't understand that dynamic, but that's the reality of it. So for instance, if someone who has insurance comes in and says, hey, judge, my client's going to be sitting in jail for 6 months waiting for a state hospital bed, they're not being recommended for community treatment, I can get the insurance to pay for a locked psych hospital. Can we do that? I can do it if the DA stipulates as a way of getting around the code, but otherwise I can't do that unless the community program director approves that psych hospital as a third option for restoration.
Who appoints a community director program?
That's a great question. It's some mechanism, it's some state mechanism. Stephanie, maybe I have not been able to sort of pull back the curtain on this one.
So
despite my efforts.
CONREP is under the umbrella of the Department of State Hospitals. And so CONREP did historically function much better when it was run by counties and county behavioral health directors, because there was an investment in making sure that people coming from the state hospital transitioned through community-based treatment before being released outright. And that changed in like the early 2000s, so that the Department of State Hospitals started contracting with for-profit organizations. And we saw fewer and fewer people getting released to outpatient treatment. And if I may just go back to the question you answered or asked me before, I am struggling with the answer, divorcing it from services, because to have any system of outpatient treatment work, there has to be services that accompany it. And I agree with Judge Bianco that there are a few problems. So one is that we have this conflict with CONREP. So even when you have a recommendation for example, let's start with mental health diversion. We've got this conflict because CONREP is always recommending inpatient treatment, and the judge is seeing that. And so it's really difficult for anybody else to recommend outpatient treatment after you've already gotten that recommendation for inpatient treatment. And then the other thing, and I agree with Judge Bianco, to make programs like CBR work anyplace else, I don't know that you can go to the counties to make that work. And I think all counties are sort of facing the same problem that LA saw, that it really took going beyond their behavioral health and using a different organization to set it up, somebody who really believed in it. And I think that that's really what we need for programs like, well, for the change in the law of SB 317 to expand community-based treatment for mental health diversion, that we really need investment from, and I don't know if it's perhaps state run. I really worry about, there's been a push like from this year's trailer bill and last year's trailer bill to realign to the counties. And I worry about that because I think where we're seeing a breakdown is with the counties having, one, the infrastructure, and two, the belief in the system working. And I think that to have a program like CBR work, it has to be perhaps more centralized, somebody else doing the hiring to make sure that there is an investment in making it work.
I'm only sighing because it's such a big problem. It's not just a problem for the law and the criminal law, but obviously implementing it, as you were just alluding to, is also a big piece of the problem. And how do you ensure care that improves people's lives and also ultimately improves public safety? I think that and fidelity to those principles, I think is quite difficult. And again, I'm avoiding as best I can question of money, because again, that's outside of our jurisdiction. I guess before we close, Ms. Peterson, we've gone sort of ping pong between the other panelists. I was wondering if there's anything here, if there's a parting word before we break for lunch, if there was a magic wand of, again, such a huge problem, if there was a discrete, practical solution that you would recommend us to pursue, where would you ask us to look?
Oh, that's a hard question, because as I prefaced with my remarks, I think this is such a complex problem. I don't know.
And I think that you're right. It's a complex systemic problem with different stovepipes of institutions that are dealing with it, that don't speak well with each other, don't speak each other's language. And meanwhile, there are seriously mentally ill people caught up in the middle of it who are obviously incapable of fending for themselves and advocating for themselves, and so much so that they can't even assist it. The core process, I realize that this is sort of where so many systems can kind of grind to a halt, but at the same time, we should try to do something. So.
Yeah, and I appreciate the question, and I don't want to hold anybody up for lunch. I think that I know that this is beyond the scope of this committee, but I just have one word, which is housing. I think providing stable housing to the folks who are caught up in this system will provide a baseline of stability that will hopefully stop the cycle of incarceration and homelessness and institutionalization that we're seeing now.
Well, that makes a lot of sense to me. With that said, again, I want to thank you all. We're going to take a break for lunch now. When we return from lunch, and I thank you again, as I said to our other panelists too, no good deed goes unpunished. I'm sure we'll be back in touch to ask you further questions as we develop our recommendations. We will discuss this topic after we come back from lunch, and then also topics from our past committee hearings. Thank you all for joining us. I really appreciate it. We'll come back at 2:20 and we're adjourned until then. Thank you.